Okay, let's talk about something that might be on your mind. That inactive company sitting on your books, quietly costing you money year after year. Well, today, we're going to explain the strike-off process. Think of it as the most efficient way to legally close that chapter and stop that compliance clock for good.
So let's just get right to it. Is that dormant company of yours a hidden financial drain? You know what I'm talking about. Every single year, you're paying for annual filings, maybe audits, and other compliance costs, all for a business that isn't even operating. A strike-off is your way out, your path to permanently stopping that cash from flowing out the door.
You know, when you decide it's time to close up shop, you're really at a crossroads with two main options. On one hand, you've got a formal winding up, and trust me, that's a long, complex, and really expensive legal procedure. But then there's the strike-off. It's so much faster, way cheaper, and a lot simpler. Honestly, it's the go-to choice for companies that have just stopped trading and have already cleared their books.
But hold on, you can't just jump straight into filing. No, there's some really essential prep work you have to do first. And getting this foundation right, well, that's the absolute key to a smooth and successful strike-off.
So, what's the number one rule? Getting to a completely clean financial slate. And I mean spotless. This means every single liability has to be gone. You need to pay all your creditors, settle up with any employees, and clear every single loan. And here's a huge point. All company bank accounts must be closed. A little pro tip for you? Start that bank account closure process early. It can take way longer than you think. And believe me, an open account is a major red flag for the registrar.
Now, beyond your private creditors, you also have to be completely squared away with the government. That means surrendering your GST registration. Seriously, leaving it active is one of the most common reasons for rejection. You also have to resolve any pending income tax issues and make sure all the director identification numbers are compliant. And, of course, any outstanding legal action or overdue annual filings, well, that's going to bring your application to a dead stop.
And you need to be aware of these specific disqualifiers under Section 249 of the Companies Act. So listen up. If, in the 3 months right before you apply, your company has done anything like change its name, move its office to a different state, or conducted any business at all, you're not eligible. Period. The company must have been truly and completely dormant. So, once you've ticked all those boxes on that pre-filing checklist, you're finally ready to start the formal application. Let's walk through this process step by step.
Okay, here's your roadmap. The whole process is pretty logical, moving from those internal decisions to the official filings. We're going to start with the board, then get the shareholders' approval, prepare all the necessary paperwork, and finally, submit Form STK2 electronically. So step 1 is the board meeting. This is where the directors will formally pass a resolution to dissolve the company. They'll approve the strike-off and then authorize one director to actually manage the process. They'll also approve two absolutely critical legal documents that we're about to look at, the affidavit and the indemnity bond.
Next up, you need the green light from the company's owners, the shareholders, and a simple majority won't cut it. You need a supermajority here. At least 75% of the shareholders have to agree. This is usually documented in a formal special resolution, which just shows that the owners are all on board with the decision to close. Now for the proof, you're going to need to prepare what's called a statement of accounts, and its job is to show 0 assets and 0 liabilities. But here's the catch. This statement has to be recent, no more than 30 days old from when you actually file. Having it certified by a chartered accountant, well, that adds a lot of credibility, and it's pretty much standard practice. Okay, this is where personal responsibility really kicks in. The indemnity bond, also known as Form STK3, is a legal promise from every single director. You are personally guaranteeing that if any legitimate claim or liability pops up down the road, you will cover it. This is how the law protects creditors even after the company itself is gone. And it doesn't stop there. In addition to that indemnity bond, every director also has to sign an affidavit, which is Form STK4. This is a sworn statement where you're confirming that all the information you've provided is true, all the debts have been paid, and that the company is in fact eligible for a strike-off. Okay, so you've done all the prep work, you held the meetings, signed all the forms, and you filed Form STK2. So now what? What happens next? Let's take a look at the official process after your application is in the hands of the authorities. So once it's filed, your application goes into a formal review. The Register of Companies, or the ROC, will first check your submission for any errors or defects. If it passes that check, they then publish a public notice. And the whole point of this notice is to give anyone, say a forgotten creditor, a window of time to object. If no valid objections come in, then the ROC issues the final dissolution notice, Form STK7, and poof, the company is officially off the books. Now, this next part is something that everyone really needs to pay close attention to. We're about to talk about the risks and the legal responsibilities that stay with you, personally, as a director, long after the company has been dissolved. First up, let's talk about rejection. Your application can be flat out denied for simple, totally avoidable mistakes. The most common reasons we see? An active GST number, an open bank account, pending filings. These are all things that should have been caught in that pre-filing stage. Getting that initial checklist right is it's absolutely essential. And this right here is a point that I really can't overstate. Section 250 of the Companies Act is crystal clear. Dissolving the company does not erase the personal liability of its directors. Let me say that again. The legal entity is gone, but your personal obligations continue.
So what does this actually mean in practice? Well, it means that if a legitimate debt or claim comes up after dissolution, creditors can come after you personally. You are still on the hook for any obligations that were incurred, and you are legally bound by that indemnity bond you signed. In essence, the law can treat you as if the company was never even dissolved. The gravity of the declarations you make here is significant. If you knowingly provide false information, or hide key facts, or apply with the intent to defraud anyone, you're not just risking rejection. No, under Section 251, you could face severe penalties and even criminal prosecution. Honesty is absolutely non-negotiable in this process.
Look, a successful strike-off isn't really the end of the story. The real final step is preparing for the fact that your personal liability continues. So, the real question I want to leave you with is this. Have you properly organized and secured all your company's records? Because if a claim pops up years down the line, those records might just be the only thing that can protect you.